All right. The third and last case that we have on the docket is Denise McDowell versus Florida Peninsula Insurance Company and James McDowell. I can tell you we're happy to have another topic of conversation, so.
Something a little bit lighter.
When you're ready.
Thank you. May it please the court. Matthew Struble representing the appellant in this case. And in this case, the trial court committed legal error by improperly allocating the burden. And the burden that was assigned to Ms. McDowell is contrary to Florida law. It's both the Second District Court of Appeal as well as the Fourth District Court of Appeal have recently reversed cases on essentially the same issue. And that issue is that Ms. McDowell's burden is to show that a loss occurred during the policy period. In this case, the instruction
specifically, wasn't that a sudden accidental loss? Is that right?
Right, yes. And
so this case boiled down to a dispute between, I guess, the experts as far as whether it was sudden or whether it was a loss that began, I guess, back in 2008 when the leak was repaired. The insurance company's position, the leak was repaired by Mr. McDowell using plumber tape, and whether that was basically what brewed and created the loss in this case?
Yeah, so that was definitely part of the issue. So under this policy, if you have a pipe in your home that fails because of wear and tear, corrosion, rust, being old age, that's not covered. But if it results in water damage, that resulting water damage is covered. And that's specifically provided for under this insurance policy. And the problem with the instruction that was given, which is clearly contrary to the actual burden, is that it was set up so that Ms. McDowell had to prove that the damages in her home occurred on that date, which would be impossible because she was never claiming coverage for the pipe. She was claiming coverage for the resulting water damage.
When you filed a motion for new trial complaining about the jury instruction, what argument did you make in that?
In the motion for new trial?
Yes.
Yeah, so that exactly, as it relates to the requirement that Ms. McDowell have to prove the damages to her home occurred during her policy period, which is contrary to the burden and impossible to actually occur. The policy provides you have a pipe, it's old, it fails, that's not covered, but this instruction made us require that we prove that as well. You could see that was compounded by the defense. What their argument was, they were focusing on pipe, other areas of the home.
Did you make an argument at trial or on the motion for new trial that the verdict form improperly shifted the burden of proof?
Yep, we did. So actually, and prior to, we filed, if you look
You're saying that you did that in the motion. Show me where in the motion for new trial you made that argument.
Okay.
You can do it on rebuttal if you'd like.
Okay, I might ask to that. What I have handy as of now is on the trial transcript, page 818, you see we explained, I referred the judge to our trial brief, which outlined the burden, and I explained to the judge that our only burden is to show a loss that occurred during the policy period. So we had briefed that issue, we argued the issue. I also provided a judge a instruction that we had proposed, which he read into the record, which was that we should have been asked, did McDowell establish by the greater weight of the evidence that there was a loss to her home during her policy period? That's what we requested, and as you can see, there's 60 pages of trial transcript arguing over these issues. Understandably, the trial judge was frustrated and ended up saying, I'm going to go with the defense's one, not going to hear any more argument, everything's preserved, and then they went on with our proposed instruction as to their exclusions. Never got to the exclusions because the only question the jury answered was one that had the burden wrong, and in this case was impossible to ever establish. And it was compounded in this case because the defense was allowed to focus on damages that weren't even part of the claim, as they did. And if you look at some of the cases we cited too, such as Citizens versus Salke out of the second DCA. First party property case as well. In that case, there had been reference to the insured having to prove that the damages were caused by a sinkhole. And that was reversed because it was found that that's not the actual burden, that's a higher standard. You don't have to prove causation as to that initial question. The only thing you have to prove is that damage occurred. And that's what the instruction should have been, and that's why we requested that specific instruction. Same issue came up on the Major versus Citizens case that we cite to, as well as a Jones versus Federated National case. And that was another one that just reversed out of the fourth, an instruction which did not properly allocate the burden. So the burden is a pure question of law. The burden in this case was to show a loss that occurred during the policy period.
That was sudden and accidental.
Yeah, I know that's a big issue in their brief to us. That doesn't make a difference. That's not the problem with the instruction, is the requirement that all the damages occurred on that date. And that's contrary to the actual provision, and as I indicated, is impossible to comply with. So in this, when we have just what's a pure legal issue that had been briefed for the trial court many times, they have their burden wrong. There's no case law showing that the burden that was given to the jury is proper. That's purely a issue of law to be reviewed by this court, and based on that requires that it be reversed for a new trial. The jury was never asked to decide the actual issue in the case and never given the instruction on the burden. And I do think it's important here when you look, a lot of these cases have come out recently, but you could see that the trial judge was struggling with this, and I know he ended up striking parts of their policy, but he had no guidance as we were going through these, because this court hasn't ruled on these specific issues, but every other DCA that's commented on it has confirmed that very basic fact. So that alone, we think is the primary basis as to the instruction. And we do think it was compounded and even more warrants a new trial when you see that the defendant was allowed to essentially unilaterally stipulate to damages. So the first day of trial, they said, hey, we stipulate to the amount of damages you're claiming, then asked the court to preclude us from putting on any evidence of damages. So we didn't even get to go into the specifics of, hey, here's what the claim's for, here's the amount she's claiming. She claimed $20,000. All that was precluded from the jury, so the jury was never been able to give that information that it needed to determine and be aware of the fact that her claim was for water damage to her kitchen cabinets, and all the other things that they talked about, such as the pipe and the wall, wasn't even part of the claim. So that was precluded as well. And we cite the case all there. A stipulation is something that had to be agreed to. We never agreed to be precluded from putting on evidence of damage. We had experts available to do so. But by them doing that on the first day over our objection, compounded the error in the jury's instruction, because the jury never even got to hear evidence as to that. As to as it's indicated, the insurance company makes a lot of issue about sudden and accidental. That's not an issue at all in this case. The issue was just very simply that we were required to meet a much higher burden than what we're actually required to prove. Based on the insufficient.
So let's, if I understand your argument, if I have a problem with a plumbing and I try to make some repairs and I do a poor job, and rest assured that if I were doing it, it would be a poor job, and it goes bad down the line, that the insurance company has to pay all the damages for everything that occurred during the entire time?
No, it has to pay for the water damage that occurred during that policy period. So it's in these policies, it's a very important coverage. You've probably seen a million commercials about it, but what you have is plumbing systems installed around this time in the 60s have cast iron pipes and they fail. And then, but the important part is the policy specifically states that if you have pipes in your home that fail because of wear and tear, deterioration, rust, corrosion, that failure, which is obviously a long-term issue, if that results in water damage to your kitchen cabinets, then that is covered. So that's what you had in this case, was Ms. McDowell had.
So your position is that while the plumbing itself might not be covered, the water damage would be covered?
Exactly, yeah, and that was our position, and the amount they stipulated to didn't include anything for the plumbing. There was never any damages claimed for the plumbing. What the claim was for the damages, the resulting damage that actually occurred during that policy period, which was the water damage to the cabinets, and that's what it was for. And the jury was never given an opportunity to rule on whether the resulting water damage to those cabinets occurred during the policy period, because it was all lumped together, and Ms. McDowell was assigned a very high burden by the trial court in this case. No other questions I'll reserve. Thank you.
Good morning. May it please the court, Lara Edelstein on behalf of Florida Peninsula Insurance Company. I'd like to reserve 5 minutes as to the cross appeal, Your Honor.
Okay.
Judge Cohen, you were correct. The motion for new trial did not raise any issues regarding the sudden and accidental language in question number 1 on the verdict form. The motion for new trial focused on whether the verdict form and jury instructions were based on the stipulation were confusing and misleading to the jury. And it also raised issues regarding the stipulation in general that the trial court should not have permitted the stipulation as to the amount of the damages.
Let's say hypothetically that I have old pipes, and so I get, and so over the course of time, because of wear and tear, pinhole leaks occur, and it's in the wall, and so I don't discover it for a little bit of time, and then all of a sudden it becomes apparent and I have an issue. Does the insurance policy cover the damage caused by the water?
It does not, Your Honor, because the wear and tear is an exclusion under the insuring provision. It says we do not insure for these things caused by wear and tear. And the water damage provision, let me get it to you. I'll read it to you. It says, we do not insure, however, for loss caused by wear and tear or deterioration. And then the paragraph below it says, if any of these cause water damage not otherwise excluded from a plumbing system or household appliance, we cover the loss covered by the caused by water. So in order for the water damage to be covered under that provision, the water damage would have to be not otherwise excluded. And here, as you know, there are many exclusions as to why this water damage to the kitchen cabinets was excluded, including pre-existing damage, neglect, maintenance, wear and tear, corrosion, deterioration. And so this paragraph, counsel is misinterpreting it because he's eliminating these 3 words, not otherwise excluded. And so under your example, Judge, the water damage would not be covered under the policy.
And then going back to your initial statement, it's your position that that the jury instruction issue is not being raised on appeal, was not preserved for purposes of appeal?
That's correct, Your Honor. Number 1, it was not included in the motion for new trial. Number 2, it was not raised during the charge conference or at any time during the trial. Number 3, the plaintiff's proposed verdict form and jury instructions filed with the court did not include any instruction or verdict form interrogatory regarding the burden allocated to the plaintiff. In fact, the instruction and the verdict form proposed by the plaintiff had to do with a breach of contract rather than any duty under or burden under the policy of insurance. And they submitted a sample verdict form from an unrelated case. It's not filed in the record, and they never stated what they wanted as far as question number 1. On page 842 of the trial transcript, the trial court decided to go with the defendant's proposed verdict form interrogatory number 1, and the plaintiff never objected to it. whatsoever during the charge conference or at any time during the trial. And so we would submit that the plaintiff has not preserved this issue for review. And so we would submit that it has to be affirmed. In addition, the verdict was not contrary to the manifest weight of the evidence because, as Your Honor said, we had a battle of the experts here. We had experts that testified that it was a sudden and accidental loss, and that we also had an expert that testified that it was a long-term in nature and not a one-time event. And so it could not be contrary to the manifest weight of the evidence.
Counsel, why your anti-concurrent cause provision, can you just explain to me briefly why you do not believe that that provision is against public policy?
Yes, Your Honor.
So you're going to go into it now? And
The cross appeal?
yes.
If Your Honors want me to, I will.
Fine with me.
Sure.
Okay. So the anti-concurrent cause is not isolated to this policy. It's very common in policies these days. And Florida courts have found these provisions to be enforceable. The Sebo case, the Jones case, and the Martinez case cited in our briefs all address the enforceability of these anti-concurrent cause provisions. And they state that the provision basically states that if there's a covered cause and a non-covered cause that causes the loss, then the entire loss, whether it was indirect or directly caused by those events, is excluded under the policy. And
So it equates to no coverage, correct?
that's correct, Your Honor.
Okay.
And so the Paulucci case that we cite to is a middle district case, and it construes Florida law, and it talks about how parties in Florida can contract around the concurrent cause doctrine through an express anti-concurrent cause provision. And the case that we talk about, Lombardi out of Connecticut, does an exhaustive review of state cases across the country and found that a vast majority of states have upheld and applied the anti-concurrent cause provisions.
So when you say contract around, you're talking about negotiations, correct? This insured was not given the opportunity to negate or eliminate or line item cross out the anti-concurrent provision of this insurance policy, correct?
Well, that's correct, but I don't know that any insured has ever, they pay for a policy of insurance and it's provided to them.
So when you say contract around, that doesn't mean negotiate. That doesn't mean take parts of the policy and leave other parts of the policy, correct?
Well, that's correct under that specific language, but like I said, these cases out of Florida and out of the Middle District talk about how these provisions are enforceable and valid, and how that parties can enter into these provisions, that insurance companies are allowed to include these provisions in their policy of insurance. The court here found that this provision was void as against public policy, but a court can only do that, can only strike a contract or a portion of a contract if it's not prohibited by a constitutional or statutory provision or a prior judicial decision based on public policy grounds, unless it is clearly injurious to public good or it contravenes some established interest of society. And this court should refuse, any court should refuse to strike a contract unless there's
It's an
prejudice.
all-risk policy. It just seems so counterintuitive that you issue an all-risk policy to a consumer who has no ability to negotiate the terms of the policy provisions, and then you put a provision like this, stick a provision like this into a policy. I find it a little troubling. It seems contrary to the whole concept of an all-risk policy, doesn't it?
Well, there's two factors that I want to address, Your Honor. First of all, I don't necessarily agree that this is a pure traditional all-risk policy because of the language that it requires. We don't cover all losses except for this, this, and this. This policy covers only sudden and accidental direct loss with exclusions and limitations. And so it's not the traditional policy. As far as
Have a listing of what's covered?
I'm sorry?
Does it list specifically what's covered?
No, it's not a named peril policy.
So it's not that. It's got to be something, right?
That's correct, Your Honor, but I think it's modified. I don't think that the traditional HO3 policy is what it's called. The all-risk policy is what it used to be. I think that over time, these policies have been whittled away, and there's additional information, additional requirements in the policies that it's no longer just that a plaintiff has to prove any loss within the policy period. It has to be a sudden and accidental loss within the policy period.
Now, if you prevail on their suit, we don't get to this issue, correct?
That's correct, Your Honor. But in any case, there is no constitutional or statutory provision in Florida which prohibits insurance companies from contracting around the concurrent cause doctrine, and so it's our position that the anti-concurrent cause provision here was not void as against public policy. A majority of the courts across the country have held that it is not void as against public policy, and we would submit that this court should also find, if it addresses the cross appeal, that the trial court erred in finding that the anti-concurrent cause provision was void as against public policy. If Your Honors want me to address the remaining issues.
It's your argument.
Okay. Well, I would like to talk a little bit about the burden of proof issue raised by the plaintiff. The plaintiff now says that, oh, well, he doesn't think that the sudden and accidental language is at issue, but they never raised it below, and it does make a difference here, and the plaintiff was required to prove that the loss was caused by a sudden and accidental direct loss. And as I argued in my brief, they didn't raise this below. They didn't raise it in the motion for new trial, and it's not preserved for appellate review. So if there are no further questions, I would reserve my remaining.
Let's assume that you have water damage that occurs over, some period of time, over 14 days. The homeowner is gone. Under the provision of your contract, that it's an exclusion if it's over 14 or more days. Aren't you responsible for the damages over the first 14 days of the policy?
Yes, Your Honor. That's not an issue here, though. What we have here is an issue where this pipe had been corroding from 5 years earlier. Even the plaintiff's expert, Bruce Holmes, testified that the corrosion inside the pipe continued from the time that the pipe was repaired with the plumber's tape until it actually burst in 2013, and that he would have replaced it with PVC pipe back in 2008 instead of wrapping it with plumber's tape. And so there's no issue here that the cause of the loss was the corrosion of the pipe starting in 2008, and that the plumber's tape was literally a Band-Aid on a problem that did not correct the issue within the pipe. And the policy does not cover that. It's clear, obviously, more than 14 days. Anything up to that time frame, if it is a sudden accidental loss, and let's say the homeowner isn't home for the first week or two and then finally sees it, then we would only be responsible for up to the first 14 days of damage. But of course, that's might be difficult to determine what starts on day 1 and what starts on day 14.
Okay.
So, but I would reserve my remaining time for rebuttal. Thank you.
All right, thank you.
Our motion for new trial was on the record starting at page 1212. The second argument was related to the jury instructions. On the 5th page of the motion, it goes in detail explaining about how the trial court improperly required us to prove damages occurring. And it goes in great detail, and the motion for new trial explains it was impossible to do, and we had explained that before it was issued to the jury because we can't possibly show that the pipe occurred during the policy period, and that's not what the claim is for. So the motion for new trial did discuss that in detail. If you look at the record starting on the trial transcript from 8:04 to 8:42. You have me referring to the judge to the memorandum of law on the burden we explained. He had our verdict question that we requested. He read it into the record. It was that the question we asked for was, did McDowell establish by the greater weight of the evidence that there was a loss to her home during the policy period? That's what we requested. That's the burden. You have two type of insurance policies. You either have an all-risk policy or a named peril policy. It's not a named peril policy. It's an all-risk policy. And all the cases that have come out that we cite to, including several in the last 2 years, have said that's the burden, that's what the question should have been, and that's what should have been submitted to the jury.
What is the language then, we insure for sudden and accidental direct loss mean? Does it have any meaning? Because under your analysis, that would have no meaning, because what it should say is we insure for anything that occurs during the course of the policy.
Yep, so it's kind of been defined as synonymous to other policies, which basically means that it's not intentional, it's not you causing it, and that's basically, what the burden is. The initial burden is to show.
Any accident that occurs any time during the policy is covered under your argument, right?
Correct.
Okay.
Yep.
So again, what is the language, we insure for sudden and accidental direct loss mean? Does it have no meaning? Do we give it no meaning?
So other insurance policies define it. This policy does not. So you give it a reasonable, meaning, and I think that would be if you come home and you have your home is flooded with water, as the evidence was, then that would be a sudden and accidental loss. The water damage, not the pipe. And
So failure to mitigate is out the door in your interpretation of this insurance policy. That means you can have a failure, in this case of the plumbing, and you can have the insured that makes a completely reckless attempt to because they're too cheap or they don't want to spend the money, they don't want to hire a plumber to come in and make repairs to the plumbing, and that results in a catastrophic failure and damage to the home, and it's going to be covered regardless of how careless the repairs were attempted by the insured.
So we didn't get to the second question, but that would have been on the second question. So the jury, would have been a jury question, but jury would be looking at her husband did a year of repair 5 years prior, it held up. Insurance company insured the property. They inspected about 2 months before. There was no damage in the kitchen. The plumbing system was good according to them. And then this water damage happened and damaged the cabinets, as the evidence showed, for the first time ever. So ultimately, if the jury wanted to exclude it on that fact pattern, it would be up to them. But we never got there because the wrong burden question was given to the jury. So we never got to the portion of the trial where the insurance company was required to prove those exclusions. And if you look at, beginning on page 233, the insurance policy is very clear that if you have wear and tear, corrosion, all those things, and it results in water damage, that's covered under your policy. It's a very important coverage, and it's not deleted, and all the case law shows what the burden is and how it should have been given. Based on that and no contrary, they don't have any argument to show that the burden, the question that was given is correct. There can't be. All the case law says that it was supposed to just be whether the damage occurred during the policy period, and you see reference to that throughout the argument at the trial, the charging conference. But the wrong burden was given. We preserved it in every way reasonably possible. We filed a motion beforehand addressing the burden. We informed the judge of it several times. We re-raised it after in our motion for a new trial again. It's a matter of law issue. They can't refute the fact that the wrong burden question was given. So when you have the jury who's to be instructed on the law, given the instruction that's contrary to law, we think that requires a new trial. Thank you.
All right, thank you, sir. All right, we'll be in recess.